Keefe D said, I want to be free, baby. I want to be free. Yes, that man got places to go, people to meet, deals to make. But hold up, wait a minute. It's a lot going on with this, you guys. I want to play a little bit of that content because I was shocked and amazed at what his lawyer set up there and said. I said, oh, heck nah. I would immediately fire that lawyer because, man, oh, no, that ain't me. I'm a redeemed man. You get what I'm saying? Like, I'm redeemed. I'm not living that lifestyle like that no more. But according to his attorney, child, it's all glorified, you guys. It is all glorified. I cannot believe his attorney sat up there in the court of law and did what he did. Infinite love, life, and good vibration. I want to get to this video now that my minute mark has passed. Yeah, the judge, like I ain't, nope, I ain't falling for all that. I'm not falling for all that. This is coming from uh, local news station in Las Vegas. Let me make sure I give the right credit to the content creator. News 3 Las Vegas. All credit is due to the channel, rightful owners of this content that I'm about to play for you.
You said the purpose of the source hearing was to ensure the bond was not posted with proceeds when talking about the murder or killing of Tupac. There was no evidence at that source hearing that Mr. Davis was paid any proceeds for the murder of Tupac. He has been paid in the past through a book, through social media accounts, etc. The only evidence that we had at the source hearing was a prospective payment. And Mr. Jones was very adamant that there was no contract between those two yet. And so it was prospective in regards to his life story. The state made comments in regards to, well, the only thing that people would be interested in regards to his life story is basically in regards to Tupac, and that's simply not true. I mean, Mr. Palal has read the books as well as I have. His life story, he was one of the most notorious gang leaders of all of Southern California. He ruled Compton. He was the
What? I know this man ain't trying to act like Keefe D is a goddamn godfather. He ruled what? Let me play that again. I know you didn't. I know he didn't get up there and say that to that damn judge.
is basically in regards to Tupac, and that's simply not true. I mean, Mr. Palal has read the books as well as I have. His life story, he was one of the most notorious gang leaders of all of Southern California. He ruled Compton. He was the godfather of Compton. Basically, he had a drug trade that extended from here to New York to Little Rock, Arkansas. He was doing 350 kilos at a time with the Mexican cartel. There's many aspects of his life that are
Look how this man looking at him like, bruh.
relevant and interesting to the community other than the death of
So
Tupac Shakur.
a lot of my initial ruling really focused on the sufficiency of the documents and proof. Ultimately, this was not obtained through illegal sources. It was because the documents gave me so many questions about where those wire transfers came from, where those counter deposits came from. $50,000 deposited at counters, typical. What we're seeing. Additionally, when you go into his drug history, things like that. So we're really looking at, is this a bond that was posted through legitimate sources? And
Right.
so that's why I was looking more into the bank records. And that's really the first part and the largest part of my ruling. I mean, I have
Okay.
concerns ultimately about the profiting off of Tupac's death, but I think my authority is somewhat limited
Right,
in the source hearing to determining whether it's legal or illegal.
right. And,
And so
and Your Honor, in regards
you gave
to,
me the June records.
right,
The bond premium was wire transferred out on June 11th. I see a transfer in right before that of $112,000 and 500 wire transferred in on June 11th and then immediately taken out in two separate payments. You provided me a check to show a portion of the payment, and the rest was, I do see wired out in the records. I don't see that check that you provided me even coming out of the bank account.
it has not yet, Your Honor. Again, we have the Mr. Jones and the Bills bond on there. What they had agreed to was pending Your Honor's ruling. He was simply going to hold on to the check, which there's funds in the bank to cover that check. But he was going to hold on to the check until the court approved the ruling and then go ahead and cash it.
So my question ultimately is, where does that $112,500 transfer come from?
Right.
Because given your client's own words, Mr. Jones was a front or middleman for this money, and so ultimately, if I know who that came from, that would give me more peace of mind.
Right, and we did provide the court with the actual company that the check came from, and that was the Agent Entertainment Touring Group, and you can see that notation in the June 11th transfer out of the bank. It says AG Entertainment Touring. Now, this is a client of Mr. Jones. Mr. Jones would testify that he received this money. This was money owed to him. He asked for that specific amount of $112,500 on the basis that he knew that he was going to use that money to pay the bill. They owe him more than that, but that was a payment that they made to his account.
Okay, anything else?
And so in regards to whether those monies came from a legitimate source, I think you have all the information there. We have a legitimate bank account. We have a legitimate business. He received the funds from another legitimate business. Your Honor can even review their website at www.agententertainment.com. It's a legitimate transaction between 100 Entertainment and AG Entertainment Touring. And he decided to use that money. In regards to any restrictions that money is for his life story, again, as Your Honor just noted, it's very limited that at this point, since he's not convicted, you cannot tell Mr. Davis he cannot receive those monies. He can receive any monies in regards to this crime until he's convicted. That's well supported by the Nevada case law. It's supported by the statute that the state had previously alleged that they were relying upon, which was 41B200.
Which case law specifically?
No, they didn't mention any case law, but I'll get to the case law. But I was just saying that the state referred to 41B200.
Sure,
the Slayer statute, which says it has to be a convicted killer. But the case law that we are referring to is the
Chad, the lawyer is just trying to get paid, you guys. The lawyer, listen, the lawyer, they already been offered deals. The lawyer is in on it now, too. Let me see something. Yeah, the lawyer has been offered a sweet deal. I ain't lying. I think this is it right here. The lawyer has a offer, and the lawyer want him to be free because the lawyer know And the lawyer even said that they want me in it too. So he's camera ready. Okay. Yeah. So yeah, he is in there pleading for the judge to allow Keefe D to get out on bail. That $750,000 that WAC 100 said that he had put up for Keefe D with no screens attached. I don't believe it, and I'm guessing the judge ain't believing it either. Fair use.
The Sears v. Lerner case. Let me get you the site.
Okay.
That's 120 Nevada, 930, 2004. In that case, it was a discussion in regards to the statute NRS 217.007. That statute was found to be over inclusive.
Can I get that site again? You said
Yes.
120 Nevada, 930?
930, 2004.
Nothing comes up. Nevadans for Nevada versus Spears? The only thing that's
Sears v. Lerner. Sears is SERES versus Lerner. I could double check the site.
Okay.
But again, in that case, it was discussing NRS 217.007. The court found that statute to be over inclusive. And that statute was the right of a victim to receive proceeds from material based upon or related to a crime. The reason why the court found it over inclusive was because it did not restrict the realm of possible defendants to just convicted felons. Additionally, in that case, in the Sears case, believe on page 930, 939, excuse me. On page 939, the Nevada Supreme Court cited to the United States Supreme Court of Simon v. Schuster. Simon and Schuster, discussing the Son of Sam statute in New York, voided a provision which denied the recovery of proceeds from telling a story by any person who has voluntarily and intelligently admitted to the commission of a crime for which such a person is not convicted. So basically, the United States Supreme Court threw out a statute on the basis that a person can admit to a crime, but if he's not convicted of the crime, he can still
Profit.
reap financial benefits from that crime.
Look, they trying to get that money. They trying, their lawyers in there work hard for your money. So hard for your money. That's right. He work hard for the money, so you better treat him right. That's all he in there for. That lawyer said, I want to be in the spotlight too. This was always his dream. This was always the lawyer's dream. Listen, you guys, I will be coming back because I just might have to go live later on. I might come in around, I don't know if people be up around that time. I might come in around 2, you know what I'm saying, 3 o'clock Eastern Standard Time over here and just do a reaction on this because this right here is giving, I want to be rich and I'm willing to do anything to become rich. Like, yeah. And now they don't got Biggie in it. OMG. They don't involve Biggie name in it. Mm-mm-mm. Say it ain't so, you guys. I mean, Keefe D, listen, Keefe D want all the smoke, okay? Keefe D said, listen, y'all want out of this damn prison, okay? Infinite love, life, and a good vibration. I'm your host, Velvet, coming through for you, and I will see you guys later.